Well, it looks like even the FBI is subject to the rule of law. A federal judge last week found that the FBI has not been abiding by the Constitution for years and is demanding for the agency to change its ways. So here's a rundown. The FBI has been writing hundreds of thousands of so-called national security letters to private businesses. These letters demand for employers to disclose private information about their clients that would otherwise require a warrant or a subpoena in order to obtain. Essentially, it's the FBI's way of skirting around court orders. The agency even tried to hide these letters by preventing businesses from even talking about them. But that's no longer the case. Here to explain why, I'm joined by Kurt Opsahl, Senior Staff Attorney at the Electronic Frontier Foundation. Hey there, Kurt. So first of all, let's start off with why are these letters so controversial?
Well, these letters are somewhat unprecedented in the American system because they allow for a demand of information from a telecommunications provider without a warrant, without a court being involved.
And are you happy with the judge's response? She did rule that it's unconstitutional, but do you think that it actually went far enough?
Well, absolutely. The court found that they were unconstitutional and said the FBI cannot issue the letters in this case, our case, and in any other case. So it's finding that the statute itself violates the Constitution.
So tell me a little bit more about your client's case and what you're hoping to get out of this.
Well, I mean, as I think everybody expects, the government will appeal. So we'll take this up to the next level, the Ninth Circuit Court of Appeal, and then perhaps to the Supreme Court, and get the court to say finally whether this type of letter is constitutional. We believe that it is not, and the court will agree.
Now, the judge's decision addressed several constitutional issues she found with these NSL letters. In her decision, she said, quote, "Moreover, there is no evidence before the court that Congress will still be concerned about the constitutional deficiencies after it had taken steps to address some of the constitutional infirmities found by district courts in the Second Circuit. Rather, it appears that in amending and reenacting the statute as it did, Congress was concerned with giving government the broadest powers possible to issue NSL disclosure orders and preclude searching judicial review of the same." So was Congress helping the FBI skirt around the courts?
Well, so after the last time the statute was found to be unconstitutional, Congress went and amended the statute. Made a few changes that were trying to address the constitutional infirmities. But as the judge noted last Friday, those steps were not sufficient, and it remained unconstitutional.
So how far up the chain did this go, this manner of supporting these letters?
Well, I mean, these letters have been around for a long time. It's just really since the Patriot Act that they have been very widely used, getting up into the hundreds of thousands of letters. But, you know, one of the biggest issues here is so few people challenge them. They are designed to be issued in secret. They come along with a gag order, and that's really the basis of the unconstitutionality here, that people who receive them aren't allowed to talk about it, and it really hasn't been able to be part of the public debate. So a lot of politicians are supporting them because I think they don't really know how they're being misused.
And that's a very interesting point that you brought up, and also the point of the sheer volume of letters that are actually being issued. It's shocking, to say the least. I want to bring up some of the letters. This is from the Department of Justice. In 2003, over 39,000 went out. In 2006, almost 50,000 were sent out. And in 2011, over 16,000 were signed, stamped, and sent out. So you had mentioned that it takes so long for anyone to really address this. Why is that?
Well, so many of these recipients, they get the letter, they see the gag order, they don't say anything about it, and comply despite the constitutional infirmities. You know, our client here really is quite brave to come forth and challenge the government on this, and looks forward to the day when it can talk about it freely.
And finally, Kurt, should these letters be banned altogether? Does it essentially create a society of spies for the FBI?
Well, I think these letters, they take the court out of the process. And one of the things I think is very important for the rule of law, for due process, is to have courts involved before companies can be required to give up information about their users, to make sure that it's a proper request and not a misuse of government power.
Do you think that it will actually slow down the information gathering process or damage national security interests by maybe possibly one day outing these letters altogether?
I don't think actually outing these letters will damage national security issues. I mean, we may find some abuse, but finding governmental abuse does not damage national security. It enhances the democratic process, which keeps our country strong.
Kurt Opsahl, Senior Staff Attorney at the Electronic Frontier Foundation, thank you for your insight.
Thank you.